There's a phrase judges use that sounds harmless, but carries enormous power: public interest. It sounds responsible. It sounds like common sense. But in constitutional law, that phrase has become a master key, a way for courts to unlock and set aside rights that the Constitution says government shall not violate. Here's the truth most people don't realize. Once a court accepts public interest as a justification to override a right, there is no logical stopping point. Every right you have can be reduced to a variable in a balancing test. Free speech, limited for public order. Privacy, reduced for public safety. Due process, relaxed for administrative efficiency. Property rights, subordinated for regulatory goals. Self-incrimination protections, suspended for urgent investigations. Once rights are weighed instead of enforced, judges are no longer interpreting law. They are making policy decisions about whose interests matter more. The Constitution does not authorize that. The Bill of Rights is written as a list of prohibitions on government, not suggestions for courts to reconsider when circumstances feel urgent. Shall not be violated is not flexible language, but courts, through jurisprudence, have transformed those fixed commands into negotiable interests. Take the public safety exception to Miranda. The Fifth Amendment forbids compelled self-incrimination, yet the court said public safety justifies questioning without warnings. That logic wasn't drawn from constitutional text. It was drawn from a policy judgment about risk. And here's the deeper danger. If a judge can suspend one right in the name of public interest, they can suspend any right the same way, because public interest is undefined, elastic, subjective. A judge can say, public interest demands censorship to stop unrest. Public interest demands searches without warrants to fight crime. Public interest demands limiting gun ownership for safety. Public interest demands restricting assembly during emergencies. Under balancing logic, rights exist only until a judge believes society benefits more from limiting them. That flips constitutional structure on its head. The Constitution exists precisely to prevent government, including courts, from deciding that expediency outweighs liberty. History shows what happens when rights are traded for promised benefits. Stop and frisk was sold as public safety. It expanded police power and eroded trust while producing disputed crime reduction. Deference doctrines were justified as efficient governance. They allowed agencies to stretch authority beyond what Congress clearly authorized. The benefits are uncertain. The rights lost are permanent. Public interest balancing gives judges the power to quietly nullify rights without formally repealing them. No amendment, no vote, just precedent. And once precedent is built, future courts cite it to go further. This is how constitutional erosion actually happens, not through dramatic declarations, but through gradual judicial redefinition of rights as interests. If rights depend on whether judges think society benefits from enforcing them, they are no longer rights. They are privileges granted by judicial discretion. And the public interest the Constitution protects most is not safety, efficiency, or order. It is liberty secured against government power. When courts redefine public interest as government convenience, they undermine the very structure meant to protect the public from the state. The question isn't whether safety matters. It's who decides when safety justifies ignoring the Constitution. The document answers that clearly. No one has that authority without amending it. Next, the doctrine that tells courts to defer to agency interpretations of law, even when those interpretations expand government power beyond the statute.